ITK
Gotcha, Sean. All right, Mr. Wakus, you're going forward today without an attorney?
Yes, Your Honor.
I've got a April 21, 25 drinking and driving file. Let's see what the paperwork says. You were here in November for a violation of probation hearing.
Mhm. Yes.
Told you to come back. We talk about your medical marijuana, right?
I've been clean. You told me to get clean and I stayed clean.
You did your alcohol class, you did your work program. Remind me, Mr. Wakus, excuse me, why are you using medical marijuana, or why do you want to use medical marijuana?
Physical pain, my arthritis. I've been out of the mechanics in the junkyard industry. 10 years. Throwing my body around.
How do you get the THC in your system?
I usually smoke and I use compound, but I've been refraining to use it because I don't know what it'll get into my blood system to make it to where I was drug testing with it.
When you say you're using a compound,
Bobby,
yeah, THC
yeah,
balm.
Yeah.
Right. And that works for you?
yeah. It did in the past. I've been.
I'm okay with that, but I don't want you smoking.
Yeah.
I would prefer you not to smoke. I'm not going to know because THC is THC. The test won't tell me how it got in your system. I just think that's a healthier way to get the THC in your body. Is smoking more effective?
Goes right to.
It's quicker.
Yeah, it's quicker to get the thing done.
All right.
But everything else then is done now that you recommended.
No, you're in full compliance. I'm going to tell you this. I'm going to let you use your medical marijuana card. I'm going to encourage you to try the lotions before you smoke. If the lotions aren't getting it done, do what you got to do.
Oh, okay.
Got it? Clarification?
Huh?
You need any clarification? Okay. How much longer we got him on probation?
He is on until September 11th.
Okay. All right. Good luck. Ma'am, what's your name? I'm sorry, last name? Are you saying better like B, like boy?
It's the whole sign. B is BOE.
B.
Is a boy. Yes. I'm sorry.
I got a Bradley, I got a Brown.
Violation of probation side? Yes.
Yeah, I don't know what that is anymore. I got a Marco Bonacea. I don't think I got another B. You got any paperwork, Mr. Rowling?
I do. Would you like to bring this up?
Yeah. I got a whole stack of Napier files. Yeah, I don't think I got them. She can hear all the really no show. All right, so how do you say it? Betcher? Yeah,
It was supposed to have 2,000 on it.
gotcha. Yeah, umlaut. That's an umlaut. Yeah, I married a German. That's the only reason I know that. All right, so Mr. Ole, is she a drinking and driving charge?
Yeah.
When did we put you on probation?
September. No, 2025.
All right. Thank you. Was it in that stack?
I didn't want to answer that.
I went through that stack twice. Here, give that back down. All right, so Mr. Ole, we're good on everything except for the positive test 12-6?
Yes, Journal, and she did admit right away.
Yeah. Yeah.
She has been very honest and very forthcoming throughout this entire.
I paid off my fines today too.
Yeah, you're completely on track, except for the testing. Are you working?
Yeah.
Where are you working?
Days a week now in Party Store.
Where at?
Jay's Food Shop in Dearborn Heights, or Dearborn.
Okay. Yeah, and you're living in Dearborn Heights too, right?
There are two students from the-
Nice. All right, Mr. Rowley, back on?
One additional day on the word program for that husband. Back on recording.
Got that?
Yes.
Okay, good luck, Ms. Betcher.
And I do bail.
Yeah, yeah. Back to Mr. Rowley.
Sign both of them.
I probably can. So how's our 3-day girl? How's our 3-day girl doing?
There's a bullet band here, skip her now. I don't understand the questions.
Did you think about it? Miss Upchurch?
It was in the stair. Why are you gonna keep that?
Because you should have thought earlier if necessary.
Any questions?
3-day jail.
Do all? No. I beat my cat. That's my feeling good.
But you get people all over.
I don't even have a cat.
I just irritated you. Just do the hard.
Why? Why'd you say that?
Some of the people.
Oh my God, she didn't even see any bad ones.
And so it gets worse.
This final courtroom moment may look confusing at first glance, but it quietly highlights one of the most dangerous problems defendants can bring into a legal setting: lack of focus, miscommunication, and not fully understanding what's happening around them. The defendant stands before the court on a violation related to probation and testing. On paper, this should have been a straightforward review. Most of the requirements were already completed, fines had been paid, the defendant had been honest about a positive test and did not attempt to deny or minimize it. In many courtrooms, honesty alone can go a long way, and here, it clearly mattered. But the hearing slowly begins to unravel. As the judge and court staff attempt to clarify simple procedural questions, communication breaks down. Questions are misunderstood. Responses don't match what was asked. Names are confused. Files are mixed up. What should have taken minutes stretches longer, creating visible frustration and concern. Then comes the moment that changes the entire tone of the hearing. A statement is made that has nothing to do with the case. A bizarre, out-of-context comment that shocks the room. The judge immediately recognizes that something is wrong. This is no longer just about compliance with probation. It's about whether the defendant fully understands the proceedings and can properly advocate for themselves in court. This is where the judge's experience becomes clear. Rather than reacting with anger or mockery, the judge slows the process down. The court shifts from enforcement to assessment. Is this confusion, nervousness, stress, misunderstanding, or something deeper that needs attention before things spiral further? The judge recognizes a critical truth. When defendants cannot clearly communicate, even when they are trying to comply, they put themselves at serious risk. Not because they are malicious, but because the court system depends on clarity, accuracy, and accountability. One wrong answer, one misunderstood question, one careless statement. That's sometimes all it takes for a situation to escalate from probation review to detention. In this case, the judge chooses restraint. The court clarifies the record, confirms what actually happened, and ensures the defendant understands what is required going forward. There is no dramatic punishment, no sudden jail sentence, no explosive confrontation. Instead, the judge delivers something far more important: structure. The defendant is reminded that court is not a casual conversation. Words matter, attention matters, listening matters. When you are standing in front of a judge, confusion is dangerous, not because judges lack patience, but because the system has consequences that don't pause just because someone is overwhelmed. This case serves as a quiet but powerful lesson. Many people believe courtroom drama only comes from shouting, disrespect, or defiance, but sometimes the most serious risk comes from disorganization and mental overload. When defendants don't fully grasp what's being asked of them, they can accidentally sabotage themselves. The judge's handling of this moment shows why experience matters on the bench. Instead of escalating, the court stabilizes the situation. The focus returns to compliance, clarity, and making sure The defendant leaves the courtroom understanding exactly what comes next. No theatrics, no viral shouting match, just careful judicial control, and that's the real takeaway. Not every courtroom moment is about winning or losing. Some are about preventing a bad situation from becoming worse. This hearing could have ended very differently if the judge chose impatience over perspective. Instead, the court ensured the defendant walked out with instructions, not handcuffs. For viewers, this case is a reminder that court isn't just about guilt or innocence, it's about communication. When defendants take the process seriously, listen carefully, and answer directly, they protect themselves. When they don't, even unintentionally, the consequences can be severe. In the end, Case 9 isn't shocking because of punishment. It's memorable because of what almost happened and didn't. A moment of confusion could have turned into a moment of regret. Instead, it became a warning. And in a courtroom, sometimes a warning is the most valuable outcome of all.